Welcome to Dad Talk Today. My name is Eric Carroll, and we have an amazing show lined up for you. We are fighting for fathers all across the United States and all across the world where you can be glad to be dad. Stick around, guys. Dad Talk Today is about to begin. Hey everybody, welcome to Dad Talk Today. It is Monday night. We've got Dad Talk Today live Q&A going on tonight. If you'll write your questions down in the comments, I'll take them to Kevin and he'll answer them. Nothing about this creates a client-attorney relationship. But with that being said, Kevin, Hickey, how are you doing tonight?
I'm doing great, Eric. How you doing?
I'm doing all right. We was talking a little bit about before we came on, one of the biggest things that gets brought to us with the show is people asking about judicial immunity. And there was a case that was brought to us on the last episode, and it looks like you've done some studying up on it.
Yeah, one of the viewers brought it up and said that there was a case out of Missouri, I believe, that was a federal court case, and that someone had gotten around the judicial immunity. And they sent the ruling to me, and I wanted to talk about that for a minute. Just a brief recap: judicial immunity, and we won't go into all of it, but basically says that judges are immune from being sued except in very, very limited circumstances. And it almost has to be criminal activity or way beyond what they were put on the bench to do in order to be sued. So this case is out of the Western District of Missouri, the Southern Division. It's a federal case. So the plaintiff is the dad, and he's got two children, and they are also plaintiffs with him because he's alleging that their civil rights were violated along with his. And they are suing the judge in the case, Judge Eric, and it's Eighmy. I don't know if that's Eigme or Eifme. I don't know how to pronounce that last name. So what happened was the dad is he apparently had a custody case going on with his two children. The judge got upset with the children and decided he would teach them a lesson and put them in jail in Taney County, that's Taney County, Missouri, and to teach them a lesson or just to scare them, basically. He did that, and then he also extended, and I'm not real clear how this happened. I think one of the parents may live down in Louisiana, but he also issued an order to have them picked up in Louisiana. And remember, he's in Missouri, to have them spend 2 nights in jail in Louisiana. So dad, on behalf of himself and on behalf of his two children, sued the judge for civil rights violations. And I can give the listing here, saying that the judge did not have jurisdiction to do what he did. The children were not parties to the action, which is true, and that he didn't have jurisdiction, and he violated their due process rights. Due process means a lot of different things, but basically it means, and it goes right into the heart of the Constitution, federal Constitution, as well as the state constitutions. We can't deprive you of life, liberty, property, that kind of thing without you having due process of law. And that can mean a lot of different things in different cases, but usually the bottom line is without you being heard and presenting what evidence you want to present. Well, these two kids were not parties to the action. I did not see the pleadings on the divorce or the custody case, so I'm assuming it was dad versus mom. And 9 times out of 10, those are the only two parties. It's the parents going after each other, and the children. And you may say, well, yeah, they are parties to it. We mean named parties in the lawsuit at the top where it says plaintiff versus defendant. Those are the parties. The children are usually just witnesses in those kinds of cases. So what happened here is you have a judge, when you kind of put all that together, that is, what's he doing? He's depriving these children of life, liberty, by putting them in jail, and he didn't have jurisdiction over them. They were not parties to this case. So dad is saying, I'm going to federal court because you violated their federal constitutional civil rights. The Civil Rights Act, we call them 1983 cases because they're in the United States Code, Section 1983. And we want relief for that. So they sued, and the defendant's judge, which is very usual sometimes with defendants, filed a motion to dismiss. Now, what that means is he is saying, look, even if you take everything they say is true in their complaint, in their lawsuit against me, you still have to dismiss this case because I have judicial immunity. And what the federal court said was, no, we're denying your motion to dismiss. We're going to let the plaintiff go forward for now. He pled enough facts. He put enough facts in his lawsuit that he has said you've gone beyond your judicial capacity. You have acted outside of your jurisdiction. That's one of those very rare instances where you can sue a judge, where you can get around judicial immunity. Now, they were very clear to say, look, we're not deciding this case on the merits. We're not saying plaintiff wins. But what we are saying is we're denying your motion to dismiss on judicial immunity grounds. The plaintiff put enough in his complaint, in his lawsuit, to show us that he's at least got a claim for now. Once you go through discovery and get ready for trial, it may turn out that there's not a claim. But for now, he has put enough in his lawsuit to get past the motion to dismiss you filed. So it'll be one to follow. And that's pretty egregious behavior, in my opinion, and definitely outside his scope. He certainly does, even though he's a federal judge, the federal courts are divided into circuits, and there's several states that are in one circuit. I don't think Louisiana's in the same circuit with Missouri. So this judge definitely it sounds like to me, has gone beyond his jurisdiction. Now, what the court will end up doing with it, we'll have to see.
We'll definitely keep an eye on that and keep bringing the updates. And I appreciate the viewers for bringing us stuff like this. Sometimes, we don't catch it. So if there's more cases like this that you guys see, bring them to us. And just like Kevin, you got that on the last episode and did his homework and found out a little bit about it. We'll definitely bring it up.
And if the viewers watching again tonight, if you'd kind of track this case and help me out and send me whatever you find on it, we'll certainly keep tabs on it.
That's it. Well, we got some questions rolling in, guys. I am going to start off with a VIP in the Dad Talk Arena, Mr. Dave Murray. He said, few cases, it seems, make it to federal court. What is the criteria for a domestic relations case to see any light of federal court?
Well, it's very rare. And the biggest thing I would say is don't plan on going to federal court with your domestic case. You've really got to show, like this dad did in that case we were just talking about. You've really got to show that some kind of civil rights were violated, something along those lines, in order to, or some other federal law was violated in order to get into federal court. You're not going to have a divorce case heard in federal court or anything like that. When you look at this lawsuit that was filed, that we were just talking about, it came out of a custody case. It might even be part of a divorce. I don't know. But the lawsuit is involving civil rights. You violated my rights and my children's civil rights. That's what that case will be about. So even on those allegations, you're not going to have a custody determination or anything like that. So your domestic relations cases are going to be heard in state court.
Yeah. Next one is from Michael Sayin. He said, question, the judge said in an order that the court will hear no more reviews regarding parenting time because she gives the PTE parenting time evaluator the right to increase time with my daughter. My lawyer argued this, but the judge said it was lawful. Right now, I only have 2 overnights a month.
Well, I hate to hear that, Michael. I'm glad your lawyer brought it up. If you're within the appeal time frame, you and your attorney may want to talk about appealing that order. Sounds like what I'm hearing is that the judge has said, when they say no more reviews, they probably mean no more review hearings. So it sounds like the judge is not wanting to have any more hearings on that issue and just let the parenting time evaluator kind of monitor the situation and determine how that's going to be increased. I don't know. I mean, talk with your attorney about it. It seems like you can't just be foreclosed from ever having a hearing on that issue again. But I mean, it seems like you should have that right. Maybe the judge thought there were too many reviews. I don't know. But talk with your attorney about it, and if it's something you might can appeal.
Next one comes from Josh Liskowaki. He said, going through a custody battle now, but looking for a lawyer. And what's the best advice to take the mother to court just for visitation and partial custody, as the mother is using the children as pawns to get what she wants, living a double-edged sword at the moment? Thanks.
Okay, this brings up a good question on visitation and partial custody. You're dealing with two different things. Visitate, and it gets even more confusing because every state uses these words differently. Some call it parenting time, some call it custody, some call it visitation. There's all different kinds of, some call it possession, some call it custody. So not sure what state you're in there, Josh, but visitation and partial custody, those are two kind of different things. Custody usually goes to more of decision-making rights as well as time with the children. Visitation is usually more just time, like the time that you're going to get. You know, the best advice is journal everything, calendar everything, keep the best notes you can so that you can take those to your attorney and let your attorney know what's been happening. On this day, this happened. This day, this happened. And that's the best that you can do. Using the children as pawns to get what she wants, you're going to want to flesh that out and give your attorney specifics on what that means. What is she doing that makes you believe she's using the children as pawns? Is she withholding visitation? Is she saying negative things in front of them? Is she saying, you don't get visitation this Friday night until you pay your child support? Those are ways that a parent can use the children as pawns. So you want to be very specific when you talk with your attorney about it, and get an attorney that's familiar with custody cases, because that's what you're going to need.
Next question from Weekend NG. He said, X is not happy with the judgment after DVRO trial. I'm guessing that's domestic violence restraining order.
Yeah.
It was denied and refiled DVRO with same issues. Final hearing trial means it's done deal, ? Can it be brought up again until she gets what she wanted, or is that going to piss the judge off?
I would take the latter approach and say it's going to piss the judge off. In fact, it should be dismissed immediately. Hopefully you've got an attorney involved. We have a thing called res judicata, which means it's been heard before. It's an old Latin phrase, which essentially means we've heard this issue before and the court has decided it before, and you can't really bring it up again. We're not going to rehash and rehear this over and over again. And I think you're dealing with a res judicata issue where she's brought this up and lost, and now this needs to be dismissed. If you have a domestic relations case going on in conjunction with this, either custody or whatever, you may want to file some kind of contempt to have the domestic relations judge hear about this, because she's bordering on litigation abuse by refiling the exact same allegations that were just dismissed, that she just lost on. So that's something you'd want to talk with your attorney about.
Yeah. I got a pretty good comment. Mr. Michael Harwood said, finally got custody of my kids. I'm glad to hear.
Excellent.
Yeah, man. We love hearing about stuff like this. This brings me to the next question, Kevin, and this is something I've actually heard quite often, and curious to talk about it. Benz Franklin said, can I get my rights back if I was coerced under duress to sign my rights off to sign off my arrears? I need help.
Okay. Well, the short answer, just based on what you're telling me, Ben, is yes. If you signed something under duress or were coerced, then yes. Now, those are very strong words. And many times in the situation you're talking about, fathers, sometimes mothers, will sign over their rights to make a child support arrearage go away. And that's all part of a deal, a negotiated deal. Now, if you felt like you were in that situation and really needed to get out from under that child support arrearage, and that's why you signed, That's not duress. That's not enough. I don't know the specifics of your situation, but duress, again, is a very hard, it's a very high burden to prove. And coercion is a very high burden to prove. And a lot of people later feel they have either, I don't want to use the phrase buyer's remorse with your situation, but they feel like they wish they hadn't done that or made that decision. Man, a lot of times that's not enough to get it overturned. So what you need to do is go to an attorney in your jurisdiction where you are. Just pay for a 30, 45-minute consultation, see what they'll charge you for that. Some may even do it for free. And sit down and tell them and say, do I have a case here to have this overturned? And, that's what you need to do. Otherwise, you're going to be wondering if you have a case or not. And this is something you need to take care of sooner rather than later. So go talk to an attorney in your area.
How hard is it for a parent to turn that back around after they've already done that, Kevin?
It's pretty much impossible. That's why you're going to have to prove something like he's saying here.
Yep.
There was some kind of flaw in the signing process, or you were promised something, or there was fraud or something like that beyond just the deal. If the deal is sign your rights over and we're going to have this child support arrearage go away, there's nothing wrong with any of that on either side. And if you sign it and then a few months later wish you hadn't, there's probably not going to be a lot you can do. No. Now, if there's other things where you're being coerced to do it or under duress, like he's talking about, you might be able to do it, but you might be able to get it undone. But those are very high burdens and very rare.
Thank you to Maureen and Izzy for sending those stars. Next one is from Donna McCann. She said, is there any way to get court access or court quick for a DNA access?
Donna, I'm not sure exactly what you're talking about. You may be talking about a paternity case where we have DNA testing. Usually it's just the parents need to get it scheduled and get it set up with a DNA testing facility. And as soon as you can do that, you can do it. A lot of times in paternity cases, we're representing the father. And so we're filing the paternity action, and we will put in there that we're requesting DNA testing, and that's to be done promptly. And usually we can either get a court order or get the mom's attorney to get that taken care of pretty quickly. You're talking about going to court. So if the other person's refusing it, then you need to try to get an attorney and get an order from the court requiring it. And that'll start getting it done for you.
Donna also said, and that's from Glasgow. I'm curious, is she talking about Scotland or is it Glasgow? And let me know in the United States. I'd be curious to find out about that.
Yeah, I would too. It's McCann. That's Scottish name. If it's Scotland, I'm going to have to put an asterisk on it. I don't know what they do there.
Louis DeVault said, what is the outcome of the 1983 case? You know what he's referring to?
I'm wondering if he's talking about the one I was just talking about. So, yeah, I guess I could have taken that a step further. Now that the motion to dismiss was denied by the defendant, then they will usually start the discovery process. They'll send out interrogatories, which are questions to answer. They may take depositions. They start preparing it for trial. So as far as I know, Louis, if you're talking about that case, it's not resolved yet. It's still going on, still pending.
Yeah. My Tumblers on YouTube said, I wrote a professional negative review about a past guardian ad litem in my case. Is he able to go after me for defamation?
There is always a defense to defamation, and that is the truth. So if what you have said is truthful, then defamation is going to be very hard. It's going to be pretty much impossible for them to come after you for defamation as long as what you said was true. Yep. Now, you can run into invasion of privacy, bringing up something about somebody that was very private, and now you've publicized it. That's a whole different deal. But as long as you were truthful in your review, I think they'll have a pretty hard time with a defamation case.
Rachel Budd on Facebook said, so today our judge in Illinois told my husband, who was taken back to court by ex, that he has to tell the kids to do as mom says, or that he'll put my husband in jail. He scrutinized my husband for keeping the kids due to COVID, even though she had done it twice to us and kept them from us. He's completely biased against my husband. What can we do?
Well, this was one of the situations, Rachel, that I almost mentioned back when we were talking about judicial immunity, where people want, they either go after a judge or file against a judge, and it's very rare to be able to do that. One of the most common reasons people want to go after a judge is because they feel like the judge is biased. They're making poor rulings, what they feel like are biased rulings against them, or they just don't like, you or the other party or whatever, and they're biased. And you just can't. It's just pretty much impossible to get a judge removed for that reason. And you have to show somehow that the judge was connected with one of the parties before. Either they represented them in a case or their firm did, or something like that. But most judges on those kinds of issues, when you bring it up, they will usually step aside on their own. Rachel, it's hard to go through a situation like that, and it feels like it's very one-sided. Talk with your attorney about it. Maybe your attorney will have some ideas. I'm not sure if you're down to your final hearing or if you just had your final hearing, but if you do feel like there were some incredibly unfair rulings and that the judge didn't really look at the evidence properly, you can always appeal it. So you'll want to talk to your attorney about that.
So this is one I haven't heard before. I'm curious to see. Michelle said, is incest a non-crime in Florida, even federally? Does it even make sense?
I don't know. She's got a laughy face there at the end, so I'm not sure about this question. Is incest a non-crime in Florida? I have no idea.
What about federally? Is incest a crime?
I would think so. I would have to look at that. Incest usually means, I guess it could be two adults. I usually, when I think of that, I think of when there's been some kind of child sexual abuse, but
Right.
I don't know. I'm gonna have to plead ignorance on all that, whether it's actually a crime. I would think it would have to be.
All right. Dan Burney on Facebook said, how do I get my kids back when my ex plays every card in the deck to exploit an already broken system? I've had 6 phone calls and 3 visits in the past year. Now she filed a TRO to cover her tracks for blatant violations of the parenting plan.
No one likes the answer that I give to this. You have got to be proactive and get in court as often as you can. This has been going on to you for a year now, and there are a lot of parents that end up in that same situation, that this goes on a month or 2. You think it's going to get better, then it's 3 or 4 months, then it's 5 months, and before you know it, it's a year. You've got to get on this early and try to file something with the court as soon as you can for, as you say, blatant violations of the parenting plan. You've got to file for contempt because she's not following the parenting plan, and get it in front of a judge. Most judges, if you can lay it out what's happening and that she's blatantly violating your order, they'll do something about it. But you got to get in front of them, and you got to get it presented to them. The TRO, hopefully you're going to win that, and if that is either dismissed or you win it resoundingly, you're going to want to bring that up in the domestic case. So that's all you can do, is go to court and make the judge aware of it, and ask the judge to do something about it.
Yeah. So it looks like we possibly heard from Scotland tonight. We've got one right here. It's not a question, but I want this gentleman, I've talked to him before. He's got something going on in the Netherlands. He wants everybody to know. Dejas van Tongeren, he said, in the Netherlands, there is momentum. Make this known all over. This might evoke the change we are fighting for. Amstelveen, April 12, 2021, due to illegal medical experiments in the youth care industry, violation of the Nuremberg Protocol. See Report Committee de Winter. Measures Dr. Henriette Nakad Wenstreit submitted a request to the public prosecutors of the International Criminal Court in The Hague to prosecute the Netherlands for crimes against humanity. He's got some information for that down in the comments. This is stuff, Kevin, you'd be shocked. Like, hear it from all across the world, man. Mm-hmm. It's crazy. Michael Sagan had a follow-up question to the above. He said, I did appeal, but the Court of Appeals said the question was not properly put before the court, so they refused to address it. I'm guessing because I did not use case law to argue the decision. What can I do now?
Michael, I'm not sure if you appealed it on your own without an attorney. You really need to have an attorney look at that. Sometimes the Court of Appeals will send it back down and say, this is over. You didn't ask the right questions and we're done and you can't bring it up again. Sometimes they remand it. They send it back down and say, this wasn't put to us properly. If you fix it, you can reappeal it and send it back to us. So you probably need to talk to an attorney to find out exactly what the Court of Appeals did in your state, and then that'll tell you if there's anything you can do or not. You're saying, what can I do now? If you can't reappeal the case, if this is a custody issue, I think it is. Maybe that, you hate to think about going back to court down the road in a year or so, but that may be what you have to do if you can't reappeal. But talk to an attorney and see if you've got an opportunity to reappeal what you had just sent up to have heard.
Jonathan Zarko on YouTube said, mother stops using OFW parenting app that's part of our parenting agreement. It happens often, causing important information to be shared. What can I do?
Well, Jonathan, it's put in your parenting agreement for a reason. That's probably Our Family Wizard is what OFW is. And that is for people that don't know, it's a great parent. I think it's a really good parenting app. It'll have a calendar on there. You put any text that you have with the other parent, you put in there, communication, you put doctor's appointments on there. You can put extracurricular activities on the calendar, and everything goes in there. So everybody's on the same page as to what's going on. And over the last several years, more and more parties and attorneys and judges have been putting it in the agreement or in the final order that app, that parenting app, is to be used. Because what happens? People lose text, or they say, he texted me something terrible. Well, where is it? Well, I don't know. If you're putting everything through the app, it keeps and tracks and records everything that you're doing so that everybody can have it and everybody can see how the communication's going. So if she's ordered to do it and she's not doing it, you need to go back to court and have her held in contempt or file a motion to have it enforced because it's put in that parenting agreement, and I'm assuming an order from the court for a reason, and that's because the two of you are supposed to be using it. And if one parent's not, then that's a problem, and it needs to be brought up.
Yeah. Dan Burney on Facebook said, how can one parent violate a parenting plan, but I get held accountable for everything?
Again, got to go back to court. You got to bring it up to the judge and show that you're complying with everything, and she is not. And that's really the only answer. If you don't, then she's going to continue to keep doing everything that she's doing, and you're not going to get much relief from it. So you've got to go in and show that she's violating it.
Angela AEG said, how hard is it to prove parental alienation in California courts? Can it be used in termination of parental rights filed by mother against father?
Well, I think it's the same in California as it would be anywhere else as far as how hard is it to prove. You've really got to show a track record. You've got to keep a good journal or calendar of what's been happening so you can show the judge, missed visitations or talking in a derogatory manner in front of the children or all the other things that an alienator will have in their toolbox. You got to bring all that evidence to court, you and your attorney, and really lay it out for the judge. If it's within your budget, have an expert there to kind of explain to the judge what alienation is, what it looks like, how it can affect the children. You need to show all of that. So in California, I do it the same way as I would any other state. As far as using that in termination of parental rights, filed by mother against father, if you're saying that the mom is the one alienating and she's now trying to terminate dad's rights because he hasn't been around or whatever, and she's the reason that he hasn't been around, he needs to come to that case, that hearing loaded with ammunition, ready to go, that here's all the alienation that's been happening. Here's what mom has been doing, and just go down that all the factors, all the things that have happened, and show that judge everything she's been doing to keep him away from the child. And because a lot of times when we have terminating parental rights, what we're talking about is one parent has not been around. For instance, in Arkansas, to terminate rights, you've got to show they haven't paid child support in a year or haven't had any meaningful visitation with the child within a year. So every once in a while, you'll see these parents that try to keep the child away for a year, and they're running around, not saying where they live, not giving phone numbers to dad and those kinds of things. When you're actively doing that, I don't think the judge is going to be letting you terminate rights. So that's something you definitely want to bring up.
Dave Murray said, have you had many clients have issues with foul treatment from school and professional sources like children's doctors? If so, how do you advise or handle that in court? It seems many fathers get treated like a second-rate citizen.
I'm not sure what he means by foul treatment. I'm not sure exactly what Dave's meaning there. I can tell you, not so much doctors, but I have come across a lot of situations where the school personnel or therapy professionals, counselors will side with one parent. One parent will kind of become allied, and they lose some objectivity there, and that can be a real problem. And you got to try to catch that early if you can. And you definitely want to let your attorney know about it if you're headed to a hearing and you think a school principal or whatever has it in for you for some reason. We can figure those things out on cross-examination if we have time to prepare ahead of time for that. But that's about the only way I know to handle that, Dave. I think that's what you're asking about.
Louis DeVault said, so a felony is found during discovery in a 1983 case. Is the prosecutor required to file charges on the offending party?
Louis, without further information, I would say no, because of the way you phrase that. The prosecutor is not really required to file charges in any case. Now, if they've got all kinds of felonies going on and they're not charging any cases, not charging anyone with cases, obviously they're not going to get reelected or reappointed or whatever. But if a felony is discovered in a 1983 civil action, and this is what Louis is asking about, there's a civil case going on, you're doing discovery, and lo and behold, somebody committed a felony. This is turned over to the prosecutor. What's the prosecutor do with it? The prosecutor can decide not to file. But depending on the case, depending on what the felony is, how strong of a case they think they have, remember, prosecutors are always asking one question: can they prove their case beyond a reasonable doubt? When they are getting ready to file, can we prove our case against this defendant beyond a reasonable doubt? Do we feel like we can do that? Normally, if their answer is yes, then they're filing criminal charges. But there are a lot of factors that go into their decision. So it'll depend on what the exact felony is. Prosecutor is not required to, but it's certainly something they're going to have to look
at. Chuck Smith said, Kevin, Eric, I was told today that the reunification therapist is in for the final destination of these kids. It was an impossible case, and when she took it, it wasn't lightly. Why do previous judges that are so prejudicial and biased avoid accountability due to judicial immunity? And when they ignore the Constitution, there's no remedial way to recover the 840 days and 1,017 days of separation when I'm reunited in June of 2022. Thanks, guys. It just sucks to lose 3 years of my children's lives so they could extort my $105,000 salary.
Yeah. I'm not sure what he meant by in for the final destination of these kids. Yeah, and I hate it, Chuck. And this goes back to what we were talking about before. If you feel like a judge is biased against you, the only way to combat that is with evidence and try to make it painfully clear to the judge, even though they may be biased against you. Judge, if you will just look at this evidence, you will see what's really going on. The judge is supposed to be objective, not subjective. They're supposed to look at this as objectively as they can, make credibility determinations of witnesses, and then make a judgment. So I know it's tough, and we hear these cases a lot. And a lot of time, judges are people too, and a lot of times they get headed down the road in a case, and they deep down they don't like one of the parties. It happens, and it's hard. It's if not impossible to get them off that train sometimes. And I don't know if that's what's happening in your case, but all you can do is present the evidence as best you can and try to get the best ruling that you can.
Chris Dodson said, general question, what happens in cases where a paternity test has proven a child is not yours in terms of biology, with child support paid over a duration of time?
That's a very good question. And it can happen. And we had a call 2 or 3 days ago from someone about this kind of an issue. If you're married to someone, child is born, that child is presumed to be the child of the father. Obviously the mother's the one that gave birth, the child of the father, the husband. When you go through a divorce, that child is still considered to be your child, and the divorce is final. But then it comes out that that the wife had an affair or whatever, and it's actually another man's child. A lot of times, there's not anything you can do about it at that point. Now, if it was concealed from you or something like that, actively concealed, or some kind of fraud by the mom, that can get into some sticky questions, and you might be able to do something about that. But a lot of times, if you're wondering about the paternity of a child, and you don't really do anything about it, and then an order is entered saying you're the father, and the appeal time passes, and then you decide down the road, I want a DNA test, and you try to do the DNA test, and you do, and it turns out biologically it's not your child, there may not be much you can do at that point if you had already been in court over it. Yeah.
I actually got a buddy, Kevin. He went on Dr. Phil about this. He went through this. He paid 11 years in child support for a child that wasn't his. And when he went to the judge and said, well, the child is not mine, I shouldn't be paying child support, the judge said, nope, you still pay child support. You should have found out sooner. Mm-hmm. He went and got legislation passed against paternity fraud in 11 different states. His name is Carnell Smith. That is something to check into, because that's a reality. We've heard of it. And
well, and while we're on this topic, we get a lot of paternity cases, or a fair amount. I mean, pretty regularly. And I usually, when I'm representing the dad, I usually ask them, "Are you you're wanting DNA testing, right? I mean, you need to do that." And a lot of times they don't. They say, "Look, the child's mine. We've been together a few years, even though we weren't married. It's obvious and all that," and so they don't worry about it. But if my client has any doubts, I really push them to get a DNA test, because that's something you want to know from the beginning. You don't want to have that as an unknown for years and years, and you may get to a point where there's nothing you can do about it. And so it's something you want to know on the front end. It really is. And I tell them, they're like, "Oh, I don't want to talk to her about a DNA test, in these paternity cases." I'll say, make me the bad guy. Tell them your attorney's telling you need to do it. And most of the time there's not a problem. It's our client's child, and we go on down the road. But every once in a while there's a surprise, and it's not. And you need to know that up front.
The last time I looked at the statistic, 33% of parents that actually go for the DNA test find out that the child's not theirs.
That's probably about right. That seems a little high to me, but is not theirs. Yeah, it seems a little high to me, but I wouldn't doubt it. And you get into tough situations that are more moral decisions and legal decisions. What do you do if you lived with this woman for 8-10 years and you guys don't ever get married, you split up, we're going to do the paternity DNA test, and it's not your child, but you raised that child for 10 years.
Yeah.
That creates tough problems, especially when the real father, whoever it is, was never involved in this child's life. So that's another reason you really want to find out these things on the front end, and then you can make decisions on what needs to be done.
If we were on this subject and I didn't say this, I'd be disappointed in myself. Just to caveat off of that, guys, home test, as tempting as it is not admissible. Mm-hmm. So make sure you get it professionally done.
It can be $200, $300, $400 sometimes for DNA testing, but man, just think about the lifetime or the 18 years of child support. Think about all the stuff involved, and you want to be able to sleep at night knowing the answer. And so it's better to find out. It's money well spent. I know it's not cheap, but it's money well spent to have it done properly.
Yeah. Louis DeVault said, I hate to say this, but felony is often where the rubber meet the road. And have you ever seen the prosecutor's office turn to the parties they are defending, quit and prosecute the judge, social worker, etc.?
Turn to the parties they are defending, quit and prosecute the judge. I don't know that I've seen that happen, Louis. I'm not sure exactly what you mean, but I'm not sure I've seen that happen.
Dan Burney said, what about approved supervisors? And I was forced to file a motion to have that same supervisor approved because X wanted my brother, who is in cohorts with said X.
Well, supervisor, I think he's talking about visitation. A lot of times judges will order supervised visitation. And of course, the next question is, what does that mean? A lot of people say, well, I'll have DHS or CPS, whoever the children's agency is, family agency is in the state to supervise it. Well, a lot of times if it's not a juvenile case or a CPS case, they won't do that. They have enough of their own caseload and they won't take private people in to supervise visitation. So the next question is, and the judges do not like being put in this situation. They will come to the parties and say, who's going to supervise? That's great. I'll order the supervised visitation, but who's going to be the supervisor? So then it's left to the parents to decide that. And I think that's kind of where Dan's is coming is that they aren't able to agree on a supervisor. So he has to file something to get an approved supervisor. Some areas, and there are some places in Arkansas that we've had help with this, will supervise visitation. There's professional companies, separate companies that will do it. You can sometimes find retired deputy sheriffs or retired police officers that on the side will come and supervise the visitation. Dan, many times it's put on the parties to figure out who the supervisor is going to be. So you just got to try to find someone like that. Maybe you can find a retired law enforcement person that might do it.
So Michelle clarified down here. She said, 2 first cousins in a relationship. Do you think a judge would believe incest involved is not in the best interest of the child, especially if bullying is already a problem due to that?
Probably. I think I'm just going to kind of leave it at that. Yeah, I think that would probably be a problem and something the judge would want to know about.
Angela AEG said, how can I win parental termination filed against my husband due to abandonment and having a felony back in 2011? He pays child support. She blocked phone number. We bought child phone, wouldn't let her use it. And the list of parental alienation moves she's made, I've documented for my husband. She's still filed and court investigator doesn't recommend his right be terminated. What are his chances he can prove alienation in California court?
Well, Angela, I can't really give you chances based on what you've told me, but I'm seeing a lot of good stuff to help him in his case. Blocking the phone number, you definitely want to let the judge know about that, especially once you bought the child a phone and still wouldn't let the child use that phone. And one of the biggest things I'm seeing, it says court investigator. I'm guessing that's kind of like maybe a parenting evaluator in California is recommending that his rights not be terminated. If I'm reading that right, you're definitely going to want that person at court. So I think you show all of these things that have happened, and with the court investigator being kind of on your side on that, I think that's going to be enough. You'll want to talk to your attorney about it, but that should be enough. The felony being 11 years old, I don't know what the felony was. Obviously, that would be important to know, and what kind of felony it was. The judge may be bothered by that, but being with it 11 years ago, if he hasn't had any more criminal history, if that is brought up, your attorney will just want to point out to the judge that it's an 11-year-old charge.
Michael Sayin said, last question, since the judge put in the order that I am not allowed any more review hearings and the Court of Appeals refused to address the question, how do I go back to court? It looks like the judge created a catch-22.
You'll have to show a change in circumstances. You'll have to show that something has gotten worse. And Michael, unfortunately, some time may need to go by. You may need several months or longer to go by before you can go back to court. You're going to have to show that things for the child have gotten worse. Child's not doing well emotionally, maybe not doing well in school, not doing well at mom's house for some reason or another. You're going to need to show all those things. And just a few weeks after this order's entered is not going to be enough time. You're going to need to let some time go by and start building a case to go back to court.
Russ Barnes said, if you appeal a custody decision and you had a guardian in the original case, is or can that guardian be reinstated as the guardian in the appeal case?
Russ, that's a good question. Usually when you appeal a case, and this gets confusing for clients, you can't introduce new evidence. You cannot introduce new evidence. So let's say you appeal your case, you hire your attorney to do that. The attorney, the first thing they will do is they will go to the court clerk and get what we call the record. That'll be all the pleadings that were filed, which are the different motions that were filed, orders from the judge, and they'll also get transcripts of any hearings. Those are what the court reporter takes down. That's the record, and that record is sent down to the Court of Appeals. And the reason the record is so important is because that's what the Court of Appeals is going to use to make their determination. Okay, you can't introduce new evidence on appeal. So the guardian ad litem being reinstated on the appeal case, they might file a brief to the Court of Appeals along with yours, and the other side's going to file a brief too, arguing that whatever they want to argue. Usually the guardians don't file, at least in Arkansas from what I've seen, they usually don't file any kind of a brief. They let the parents kind of fight it out when it goes on appeal. Now, if the Court of Appeals sends the case back down to be reheard, that guardian ad litem, unless somebody objects or there's some kind of problem, will more than likely be reappointed in the case. So be looking for that if the Court of Appeals does send it back down to be reheard. Or if you reopen the case in the future, a lot of times judges like to reappoint the same ad litem or guardian that they had before because they're familiar with the case and they don't have to get up to speed, and hopefully that'll save the parties some attorney's fees. So I hope that clears that up.
Michelle said, for a first contempt of court is likely that it would either be fines or community service. What happens usually if both parties are in contempt? Would it equal out?
It depends on what the contempts are, Michelle, but yeah, I mean, if both parties are in contempt, usually the judge gets equally upset with both of them. They want, we say it on here all the time, judges want their orders followed. They put things in order for a reason. And the hope is that they don't see you back in court. If you come back to court because there's new issues, they understand that. If you come back to court because you're not following the order that they put in place, they understand that too, and they're usually not very happy about it. So if both parents are not following it, chances are the judge won't be very happy with either one.
Dan Byrne said, no matter what I introduce, the judge has denied it every time. What can I do? What happens when they just don't care about the judicial process?
Dan, I don't know if you're representing yourself pro se or if you have an attorney. If you've got an attorney, he or she should be able to get that evidence into court, into the record. I'm not sure what's happening there. And judges will deny evidence for a lot of reasons. They think it's not admissible because it's hearsay. This judge may think that he's seen that evidence before more than once and knows what it is, and so he's not introducing it again. There are a lot of reasons a judge can deny it.
Yeah. Weekend NG said, fighting mother-in-law for my children. Ex isn't interested in taking care of the kids, only focused on her career. Mother-in-law has been preying on the kids and convinced her daughter to get rid of me and wanted sole custody. I've been taking care of the kid the past 3 years. They didn't expect me to fight back. Is there a way to get more than 50-50 since X isn't taking care of the kids, but the mother-in-law instead of me?
Okay. Yeah, it says fighting mother-in-law for my children. I mean, does the mother-in-law have some kind of guardianship? He says he's been taking care of the kids the past 3 years, which makes me think he has custody. If mom is trying to come back and claim that she wants the kids for extended time, you're just going to have to show that it's really the mother-in-law that's taking care of them instead of the mom. And that's just going to come down to the evidence that you've got.
He said, no, she does not.
She does not have custody.
Mm-mm.
Okay, so I think he's got custody then. It says he's had him. He's been taking care of him the past 3 years. So parents always have superior rights to a grandparent. That's where you start. Mom and dad always have the superior rights until those rights are changed, terminated, or something's going on with one or both of them that would require a guardianship to come into place, which many times is a grandparent or some other relative that comes in. But the parents always have superior rights to the grandparent, which would be the mother-in-law in this situation. So that's the biggest thing that you have going for you.
Yeah. So we're about to hear from somebody. I remember when this happened. It's been a little while ago, but this is a sad situation. His name is Zach Hoffer. He said, the man who adopted my daughter at age 16 after I raised her until age 13 is on trial for the first-degree homicide of her. He killed her. They won't bring up his extensive criminal history, but have torn me apart just like family court. How is this fair? Why does the system love to do harm to those who haven't done the crime in question?
Man, Zach, I'm sorry to hear about that. Manhood, age 16.
Yep, I remember hearing about this. Zach, reach out to me after this too. I'd like to talk to you, brother.
I'm guessing he's saying that's at the criminal trial. They're tearing him apart. I would just have to have been there, Zach, to really see what they're kind of going into with you on the stand. They sure need to be focusing on him and what he's done. He's the one that committed the homicide. So I'm sure sorry, and I hope it gets better.
Yeah, man, reach out to me. I got some questions about it. It's even been a while for me, but need some more pieces of that puzzle so we can get you some information. Dan Burney said, what if the ex has a diagnosed mental incapacity? She has a benign brain tumor that she takes medication for. Do I have a case?
Well, Dan, again, I don't know if your case is concluded because of the appeal or whatever. It depends on what the mental incapacity is. And that's going to come down to what the judge believes as far as, does this mental incapacity keep her from being able to properly take care of the children? Lots of people have mental issues, diagnosed mental problems, and either with medication or because the mental problems are minor, are perfectly okay to take care of children. But if she's not, and that is affecting her, you're going to want to make sure the judge knows about that, and that it's not a good situation for the children.
Rachel Budd said, how long do you have to file an appeal?
Rachel, that's an excellent question. And it's different with every state, and can even be different with the type of case that you have. So a divorce case in one state may have a different timeline than a civil case or something like that. In Arkansas, you have 30 days from the time the domestic relations case is over to file an appeal. But I'm not sure what state you're in. You will want to check with an attorney in your area. You can Google and probably find it out, but I try to not rely too much on the internet for that kind of information. It's a good starting point, not an ending point. But you can Google some of that on timelines for appeals in your state and find out. And to know for sure, though, talk to an attorney.
Yeah. I got some people wanting to reach out about their stories. We heard from a lot of people tonight, guys. Make sure you're getting in that Dad Talk Today support group right after this broadcast. Robert Garza, he's been going one-on-one talking to some of these parents about their stories. A great place to talk to each other and hear from other parents that are going through similar situations. Kevin, some of the stories that we hear, man, they're gut-wrenching, and
they are. And I kind of want to dovetail on what you just said, and something that we tell our clients a lot, and we tell our staff to tell our clients, and that is, if we feel like the client's kind of going through this on their own, we ask them about close family that they have, close friends that they have, pastors, ministers at church, support groups at their church. Don't go through these things alone. It's very easy to want to internalize these things because they can be embarrassing. They can be things that you don't want to talk about. Try not to internalize it. Talk to people that you trust, that you love, and that love you, and can help you get these things off your chest and talk to them. And the support group that Robert does is an excellent place to start with that. And but people that are important to you in your life, I'm telling you, they want to help you, and they want to be. You've got people in your life that want to listen to what you have to say and help you, and take advantage of that. They may need you someday. So talk about it and lean on the people that are close to you.
Yeah. Got a little bit of a long one. I'm going to read this from the phone from Mark Mooney. He said, I left my ex 2 years ago due to her drug issue and abuse from her to me in front of my boys. I left to get a better job and get them. And in the meantime, my boys were taken from her and put into Missouri state custody due to methamphetamine in their hair when tested. She has been in and out of jail, but since they have been taken away, they called, but didn't give me custody since I was in another state. So they said, I've told them I want them from the start, and I'm on the birth certificate. We weren't married. She has drug charges and obviously was using around my boys more than once. My record is clean other than a DUI. What should I do to get custody, and why can't I just get them anyways, even though they are placed in foster care? When I told Child Protective Custody, I would take them from the time they were taken. Yes, they had me paying child support when I would gladly take my sons whose ages are 6 and 4.5.
Well, with you paying child support, Mark, it answers one question I've got. I know you said that that you and mom were not married and that you're on the birth certificate. Usually for most states, that's not enough to give you legal rights as the father. There has to be a paternity action to legally declare you the father. Usually what goes along with that is paying child support. So I'm thinking, since you're paying child support, either as part of this case or another case, you were declared the father, legally the father. That's the first hurdle you've got to get over. A lot of times when these cases start and they come in and take the children away from the mom, and the dad is out of state, but he says, look, I'm the dad, I'm here. If you're not legally the father, it takes a while to get the paternity testing done, the DNA testing we were talking about earlier, and get your rights established. Then they can start looking at if you are an appropriate placement for the children. Until then, unfortunately, normally the children are in foster care until we can find that out. You've really got to push to get in there and make your rights known, and you've got to get an attorney in that state. I had a situation like yours, Mark, very similar. Started about 1.5 years ago. We were representing a father out of North Carolina that had had very limited contact with his children. Mom, bad situation for her. DHS, CPS case was opened, and it took a while, and it took a lot of fighting, and it took a lot of staying in there, but we finally got custody for him after months and months and months and months, even though he was in North Carolina and the case was here in Arkansas. It can be done. You've got to be persistent, and you just got to get an attorney there that's going to fight for you. And hopefully your situation is a good situation there that the court's going to be okay with. One thing that's going to happen since you're out of state is they're going to have to do what's called an ICPC. That is a special evaluation that they do of you and your home, where you work. They'll do a background check on you. It usually takes a few months, unfortunately, when someone's out of state. They can do these background checks and all of that within days when you're in state, but when you're out of state, there's all these interstate laws that have to be complied with. So, but you want to start that process sooner rather than later, so you can try to get custody.
Yeah. Kevin, this Saturday will be a year since we lost John Mast. And I got a call from you, I think it was last week. We saw the news. There was another father that got killed up in Virginia the week before that. The pastor that got killed up there in Tennessee, I believe his daughter was killed in the process too. Mm-hmm. I know we was talking a little bit about the dangers at these custody exchanges and stuff earlier as well. I mean, any thoughts on some of that news that we've been getting?
It's been terrible. The one in Virginia was at a police station, and And something you and I have talked about a lot, Eric, it's not normally the other parent that does the crime.
Yep.
It's usually either a boyfriend or girlfriend. This one over a week ago in Virginia was my understanding was the mom's new boyfriend shot the dad at the police station. It could be a grandparent, like in John's case. It can be all kinds of people, but it's normally not the other parent. It's somebody peripherally around. And, judges, a lot of times, if there's no problems, they don't mind if other people are at visitation exchanges, but we're going to have to really start re-looking at who can be at visitation exchanges. And if a significant other or a family relative has been a problem at a visitation exchange, judges around here where I practice have no problem excluding them from the visitation exchanges. But it's like we talk about, nothing's 100%. That's a piece of paper saying they can't be there. That doesn't mean that Saturday at 9 p.m. at the grocery store, they won't show up for the visitation exchange and do something.
Right.
They really have it in their minds. So these things are, I hate to say they're becoming more common, but they seem to be, and they don't seem to be de-escalating in severity. I mean, these are resulting in severe injuries or death almost every time. And all I can say is to the parents out there, if you think that the other parent or someone that's with them on a regular basis could potentially do something like this, you've got to take steps to protect yourself, because this was not a one-off situation. This is happening regularly. It just is. And you need to go to the police station. You need to figure out a way to maybe stagger how you're picking up the child, dropping off the child, something. Nothing's 100%, but you can do some things to try to lessen the chances that it'll happen.
I know we've talked about it, taking precaution, trying to limit that contact, and all these other solutions. If a parent feels like this conflict is just taken off and they have in their heart that something like this could be possible, any type of solution that they could take in court. I know it's hard to prove what somebody's got in their heart before they do it, but you got any suggestions there?
I think if you've had some issues, then I think a judge will listen to anything that you want to put into an order to try to make sure there's safety there for everybody involved. But you've got to have some support. Either something's happened in the past or threats have been made. I think that will be enough to get a judge's attention, especially with the things that have been happening the last 1, 2, 3 years, and how this seems to be getting worse instead of better.
Yeah. All right, guys. I'll be doing something this Saturday in tribute to John. I'm not too sure yet, but I know we definitely want to be on here. It seems like just this past year we've been working on that so hard. It flew by. Mm-hmm. And like you said, those cases seem to be just hitting the headlines more and more. And we're steadily in conversations, guys, trying to think of what we can do to get, some type of relief with that. And prayers to all the families of those that have been affected. But Kevin, that's going to bring it to the end of the show. If there's anybody that would like to reach out to you about your services, or tell them about some of the resources on your website.
My office is located in Fort Smith, Arkansas. We actually have 3 offices, one in Fort Smith, one in Northwest Arkansas in Rogers, and then one in Russellville, Arkansas. And but as far as high conflict custody cases, I take those cases anywhere in the country. If you hire me and bring on our firm, I work alongside your local attorney. Those are usually cases involving severe parental alienation, false abuse allegations. If CPS has gotten involved, those kinds of things, we come in and, like I say, we get admitted to your state to practice in your case alongside your local attorney. And as far as our website, it's kevinhickeylaw.com. That's all one word, kevinhickeylaw.com. We have a lot of information on there about CPS, parental alienation, divorce, custody issues, all kinds of free information for you that you can go on there and check out. And if you want to call us for a consultation, we're happy to talk to you. It's 479-434-2414. And if you mention Dad Talk and tell them that's how you found out about us, the initial consultation is no charge. So be sure and mention that.
All right, guys. Hey, Kevin, I appreciate it. Thanks for everybody to writing in, and we'll do it again in 2 weeks.
Hey, one other thing, Eric, if I can quickly, Jim Bashir's trial is currently set for the week of March 21st out in Lewiston, Idaho. There is a pretrial conference coming up, I think, in the next 2 or 3 days that may kind of solidify that it's, continuance has happened, but may solidify that happens that week. And we'll keep everybody informed and advised of what's going on that, and kind of what, Eric, mine and your activities are going to be during that week, because we're going to be out there. And but anyway, we'll keep you advised on what's going on. The family could sure use support.
They absolutely could. And guys, if you would go to the John Mast Foundation, they're on Facebook. I know, like Kevin said, we'll be there on location that week, and I'll be keeping some updates going on that page. And yep, and prayers for the family. I know it's going to be a rough time, but Kevin, we'll do it again in 2 weeks, brother.
Sounds good. Talk to you soon.
All right, guys. Hey, everybody, Eric Carroll here. Thank you for tuning in to another exciting episode of Dad Talk Today. While we fight for you, we would ask for you to please help fight for us. Like, subscribe to our channel, and ring that bell so you get notifications every time we go live. There's also Super Chats, patreon.com/DadTalkToday, and other ways you can support our channel. Thank you for being here, and we will see you next time.